Hello everyone. Welcome to the first lecture of the Indian Contract Act 1872. Now, in my earlier lecture, I had discussed that law is nothing but a set of rules. When all these rules they come together, it forms an act. When many acts come together, it forms law. So all these rules, when they come together, it forms an act. And the act that we are going to discuss today is the Indian Contract Act 1872. Now, the act is further divided into chapters, and chapters are divided into sections. If you go through my textbook, you will find that the Indian Contract Act is divided into various chapters, and each chapter has sections. These sections cover a particular concept. Now, the Indian Contract Act has a total of 238 sections. Section 1 to Section 75, they discuss the general provisions which are applicable to every contract. So these are the general provisions which apply to each and every contract. Section 76 to 123 related to sale of goods. But these sections were later on repealed. Okay, repealed means they were removed from the act as if they never existed. These sections were covered in chapter 7. I had discussed with you that the act is first divided into chapters and chapters are then divided into sections. So the entire chapter 7, which consisted of section 76 to 123, was repealed. Repealed means it was removed from the act as if it never existed. Okay, so this was repealed, and the Sale of Goods Act 1930 was formed. Section 124 to 238, they cover provisions which relate to certain special kind of contracts. So these are special provisions which apply to special type of contracts like indemnity guarantee, bailment pledge, and agency. So these are special provisions. Yes, we need to study the special provisions also. Now, to these special type of contracts, the general provisions of section 1 to section 75 apply, and in addition to that, certain special provisions shall also apply. The Contract Act also consisted of section 239 to 266. Now, these sections related to partnership, and all these sections were covered in chapter 11. Okay, so the entire chapter was repealed. Okay, this chapter was also repealed, and the Indian Partnership Act 1932 was formed. So if you see today in the Indian Contract Act, you will find the general and the special provisions only. The Sale of Goods Act, the entire chapter, and the Partnership Act, entire chapter, was repealed and respective acts were formed. Section 1 to section 75, which cover the general provisions, as well as section 124 to 238, which cover special provisions, are applicable for your exam. So we are going to study everything properly and in detail. But before I discuss the concepts, I would like to inform you that the Indian Contract Act 1872 came into force on 1st September 1872. Which date? Yes, 1st September 1872. Could you repeat it for me? The Indian Contract Act came into force on 1st September 1872. Now, this act came into force on 1st September 1872. It means it applies to all the contracts entered after 1st September 1872. But, ma'am, there would have definitely been contracts entered before 1st September 1872. But the Contract Act was not applicable then. What applied? We discussed in my earlier session that the personal laws, yes, the personal laws applied. So if the contract was between two Hindus, the Hindu law applied. If the contract was between two Muslims, the Muslim law applied. If the contract was between one Hindu and one Muslim, then the law, the personal law of the defendant applied. So we had discussed all this earlier. But what if, ma'am, there is no personal law or the personal law is silent? Then in that case, English law applied. Even today, if we get stuck somewhere and there is nothing to guide us in the Indian law, today also we refer the English law because we have the same judiciary system. We have adopted the judiciary from the Britishers because they ruled us for many years. So yes, because our judiciary system is same, in if you do not find any solution in the Indian laws, you can even today refer the English law. But that's a very rare scenario. Mostly everything is found, all the answers will be found in our Indian laws. We have kept amending the laws. We have tried to incorporate many such provisions which are very relevant to our Indian judiciary system. So, if the contract is between two Hindus or Muslims, or the Hindu law also applies to Buddhists, Jains, Sikhs. So, if there is a personal law, then that personal law applied, and if there was no personal law, or if the personal law was silent, there was no solution in it, then the English law applied. Now, what about the contracts which were entered before 1st September? They were either governed by the personal law or the English law. But it is so unfair, no? To divide the country on the basis of religion. Acha, you are a Hindu, Hindu law will apply. Oh, you're a Muslim, Muslim law will apply. Now, there were even provinces which were governed by the king. So, the king's law, because the Britishers, they were not present throughout the country. There were certain places which they had given to the kings, the local kings to be managed, and these kings would collect revenue and give it to the Britishers. So yes, in the princely states, or where they had, the Britishers had collaborated with the local kings, then their laws also applied. So there were many laws which were applicable. There was no uniformity. So prior to 1st September 1872, we were divided on the basis of religion. There was no uniformity. But after 1st September 1872, we said nothing doing. We are not going to divide the country on the basis of religion. You may belong to any religion, but the Indian Contract Act will apply to all the contracts which are entered in India after 1st September 1872. So, from 1st September, the act was applicable. So, this was a uniform law applicable to all the persons present in India and entering into contract in India. Now, the Indian Contract Act applies to the whole of India. There was a time when when there were many laws which were applicable to the whole of India, but they were not applicable to the state of Jammu and Kashmir. But after 2019, after introduction of the Jammu and Kashmir Reorganization Act 2019, okay, the Jammu and Kashmir Reorganization Act, I'm not writing in full, I'm just using short forms. Jammu and Kashmir Reorganization Act 2019. After introduction of this act, the all the acts, they apply to the whole of India. But are you aware why there were certain acts which were applicable to the whole of India but not the state of Jammu and Kashmir? Are you aware of the story? I have you heard Article 370? There were so many movies which were released after 2019, after the Jammu and Kashmir Reorganization Act. All right, let us discuss the story. Story time. Article 370. Now, at the time of partition, the king of Jammu and Kashmir, Maharaja Hari Singh, said that Kashmir is like Switzerland. I don't want to give it to either India or Pakistan. I want to be independent. But I'm sure you are aware that Pakistan always wanted the state of Jammu and Kashmir. They always wanted Kashmir. So they sent their army, their tribes, their troops to invade Jammu and Kashmir. The king got scared. He thought that at this rate, considering the number of people who are invading my state, they will capture me. So he then went to the Prime Minister of India, Pandit Jawaharlal Nehru. He said, Nehru, please help me to save Kashmir from these Pakistanis and various other tribes who have joined Pakistan and they are trying to capture Kashmir. Please help me save Kashmir from them. Panditji said that listen, you are not a part of India. So, how can I give my Indian army to defend you? You do one thing, why don't you give Jammu and Kashmir to India? Why don't you give Kashmir to India? Then in that case, I can give my Indian army to defend you. But Maharaja Hari Singh said, no, no, no. Kashmir is like Switzerland. I want to be independent. So Panditji came up with a solution. He said, all right, I will introduce Article 370 in the Constitution, after which you will get the right to frame your own laws, your own regulations. You will have a constitution of your own. Are you aware, students, that Jammu and Kashmir for so many years was the only state having its own constitution? They were framing their own laws, their own regulation. We in the center, if we wanted to introduce any regulation, we needed the state government's permission, also known as the state government's concurrence. So Nehru ji came up with a very good, brilliant idea that let me introduce Article 370 in the Constitution, after which you will, although you are a part of India, you will get the right to frame your own laws, own regulations. So indirectly, you get to stay independent. So Maharaja Hari Singh agreed. But the other states of our country, they were like, we also want to be independent. We should also be given the right to make our own laws. We also want our own constitution. Pandit ji said, Are, listen, this is just a temporary situation. At least we got Kashmir. I have imposed Article 370 for the time being. I will retract it later. But you know, in India, once something is introduced, it is very difficult to take it back. So, for all these years, right from 1947 till 2019, Jammu and Kashmir enjoyed a special status. It was a blessing as well as a bane. Okay, so boon as well as a bane. So, I don't want to get into that, it is too political. So after Article 370 was introduced, Jammu and Kashmir had the right to make their own laws, right to frame their, they had their own constitution. So there were many laws which were applicable to the whole of India, but they were not applicable to Jammu and Kashmir. But in 2019, the Modi government said that Kashmir is very much a part of India. Why should they have separate laws? So they removed Article 370 from the Constitution, and now the laws, the acts apply to whole of India. They also apply to Jammu and Kashmir. So that was the story behind Article 370. Wasn't it interesting? Yes. All right, I have discussed so many things about Contract Act, but till now I have not introduced the meaning of the word contract. Let us try to understand contract with the help of a very practical and interesting example. Let's say that Karan Johar wants to make a movie बहुत कुछ होता है, which will be a sequel of कुछ कुछ होता है. So he approached his favorite actor Shah Rukh Khan. He said, Shah Rukh, I want to make a movie बहुत कुछ होता है which will be a sequel of कुछ कुछ होता है. Will you act in my movie? Shah Rukh says, all right, you leave the script, I will go through it and I will let you know. So Shah Rukh read the script and he said, fantastic, I will work in your movie. Karan says, see, promise na. Later then don't tell me that I don't have dates. I don't have time. Are nahi nahi, all the dates are yours. Anyways, I don't have any other movie. Okay. Then Shah Rukh says, how much money will you give me? Karan says, I will give you some X crores of rupees. Promise na? Later on, don't tell me that I don't have money. Are nahi nahi, pakka promise. So they made many promises to each other and they went home. In the evening, when Shah Rukh was sitting in his office, he thought, what if Karan decides to cast a younger actor, Ranbir Kapoor, instead of me? What if he says that I'm too old for the movie? I have given him dates. I will lose a lot of money. So he called up Karan and he says, Karan, we need to meet. Karan says, okay. It's a business meeting. Don't think otherwise. Just friends. Okay. So he said, Karan, we need to meet. Karan says, okay. He said, come to my office tomorrow. So when Karan came to Shah Rukh's office, Shah Rukh says that, listen, Karan, what if you decide to cast a younger actor Ranbir Kapoor instead of me? I have given you all my dates and I will suffer a huge loss in that case. Karan says, Are, you are my best friend. I won't ditch you in this manner. Shah Rukh says, no, business and friendship are two different things. I don't want to mix them. If you don't cast me in your movie, I will file a case against you. Karan says, see, I won't do that. But if you refuse to work in my movie, even I can file a case against you. Fair enough? From this, we have come across many elements of contract. The first one being a promise. A proposal, when accepted, becomes a promise. A proposal, when accepted, becomes a promise. What is the meaning of proposal? Proposal means offer. So a proposal, when accepted, becomes a promise. Look at my actions. They will help you to memorize the definition. A proposal, when accepted, becomes a promise. In my example, who had given the proposal? Karan. And who had accepted that proposal? Shah Rukh. A proposal, when accepted, becomes a promise. Was there just one promise in my example, or were there many promises? Yeah, there were many promises. Will you work in my movie? Yes. Will you give me the desired dates? Yes. Will you give me X amount of rupees? Yes. There were many such promises. When all these promises they come together, it forms an agreement. So what is an agreement? Every promise. See, if there is just one promise, then also it is an agreement. And when many promises they come together, that also makes an agreement. So every promise, it means even if it is just one promise, it'll be an agreement. And every set of promises forming consideration for each other is an agreement. So every promise and every set of promises forming consideration for each other is an agreement. I don't want to learn such lengthy definitions. I want a simple equation. Agreement is nothing but offer plus acceptance. Ma'am, there is something which you underlined, but you did not explain. What is it? Every promise and every set of promises forming consideration for each other. Now, what is the meaning of consideration? Consideration means something in return. See, nobody promises to do anything for free, okay? You don't get any free meals. If I am giving you goods, I need money. If I'm giving you services, I need money. If I'm giving you money, I need goods, I need services. So each party must get something in return. Only then it is an agreement. Now, in my example, Karan offered a movie to Shah Rukh, and Shah Rukh offered his services or skill. Okay. Now, in this case, if Karan is giving money, what is he getting in return? Services. So, what is the consideration for Karan? Services. Services of Shah Rukh is consideration for him. If Shah Rukh is giving his services, what is he getting in return? Money. So, for Shah Rukh, money is consideration. Yes. So, if you are giving something, you should also get something in return. Whatever you get in return is consideration. Both the parties must get something in return, only then it is a valid agreement. We will leave the concept of consideration for the time being. Okay, leave it for the time being. Let us revise. What is a promise? A proposal, when accepted, becomes a promise. Every promise and every set of promises forming consideration for each other is an agreement. The equation is offer plus acceptance. Were there just this many facts in my example, or was there something else? Was there something more? Yes? What? Yes, if one party defaults, other party can file a case. You can take action. You can take legal action. That aspect was also covered. If you don't cast me in your movie, I will file a case against you. That element is known as enforceability. Enforceability means intention to sue, intention to file a case. If one party defaults, other party can take action. I'll write that also. If one party defaults, other party can take action. When all these three elements they come together, it forms a contract. So contract is nothing but an agreement enforceable by law. Enforceable by law, it means it has the element of enforceability. If one party defaults, other party can take action. When all these three elements they come together, it forms a contract. Contract is nothing but agreement plus enforceability. What is an agreement? It is offer plus acceptance. So, can I say that contract is nothing but offer plus acceptance plus enforceability? Enforceability is something which distinguishes agreement from contract. What is the meaning of enforceability? Enforceability means parties must have an intention to sue, they must have an intention to file a case. If one party defaults, other party can take action. See, if there is no enforceability, it means that agreement has no legal standing, it has no legal recognition. If I don't have an intention to file a case, law says that I don't recognize that at all. If you're not going to come and file a case, so it is of no use to me. So mere agreement is just like, two parties who are agreeing to do some things. But if one party defaults, other party will never be able to take action. So law says, what is it of any use to me? It is just an agreement. You both settle it. But only when I show intention to sue, when I show intention to file a case, then it becomes a contract which is legally enforceable. It has a good standing in the eyes of law. The question arises, how will we show this intention? Is it always compulsory that contract must be in writing? No. Oral contracts are very much valid. Now, let's say that I am teaching you in a live class. I just took few thousands as fees from you and I started teaching and I said you pay the balance next month. It was just an oral agreement between us, but all my other students, staff members were also standing as witness. So it is understood that if I am giving you services, I intend to be paid for it, and if you don't pay, I will file a case. So oral agreements are also valid if we properly show. See, you need not always tell, if you don't perform your promise, I will file a case. There are certain cases in which we assume, there is an, I will teach you all that. I will go through various examples and you will be able to identify. But please note, students, that every time parties will not expressly say that if you don't perform your promise, I will file a case. There are certain places wherein you have to apply your logic, you have to apply your own understanding, and then decide, is it enforceable? If yes, it is a contract. Otherwise, it is just an agreement. Ma'am, we don't understand concepts just by one example. We need to discuss more examples. Of course, I have more examples for you. But before that, can you revise? What is the equation of a contract? Contract is nothing but agreement plus enforceability. What is an agreement? Offer plus acceptance. So can I say to make a valid contract, I need offer, I need accept. Oh, my battery. I'll just put it for charging. Okay. So to make a valid contract, I need offer, I need acceptance, and I need enforceability. Let us discuss more examples to clear our concept. Now, if all these elements are present, only then it is a valid contract. Otherwise, it is just an agreement having no value in the eyes of law. See, when you can't file a case, then it is of no use, no? Mr. X agrees to sell his house to Y for 50 lakh rupees. Okay, so Mr. X agrees to sell his house to Mr. Y for 50 lakh rupees. All right. So X asked Y, will you buy my flat for 50 lakh? He said, yes, I will buy it. Was there offer? Yes. Was it accepted? Yes. What becomes? It is an agreement. Yes. What does it become? It becomes an agreement. But to make a contract, I need enforceability also. What if X gave the flat, but Y refused to pay 50 lakh rupees? Can X file a case? Yes. There is enforceability. Is it a contract? Yes. X tells Y, take 5 lakh rupees and kill Z, Supari. Y said, okay, consider your work done. Was there offer? Yes. Was it accepted by Y? Yes. X gave money, but Y did not kill Z. He said, no, no, I have stopped all this now. Can X go to the court and tell the judge, Judge, he has taken 5 lakh rupees from me and he's not killing Z. Ask him to go and kill Z. Is there enforceability? No. Will this be a contract? No, absolutely not. It's just an agreement having no value in the eyes of law. See, if you cannot file a case, then law says it is of no use for me. So, an agreement has no value in the eyes of law. Okay, one more example. X and Y, they were watching a cricket match, India Pakistan. X says, Are India will win. Y says, No, no, very poor performance. India will lose. You want to bet? They have entered into a bet. Was there offer? Was there an offer for the bet? Yes. Was it accepted? Yes. India won the match, X won the bet, but Y is not paying money. Can X go to the court and say, Judge, we had entered into a cricket bet and he's not paying money. Ask him to pay money. You will get arrested. Cricket betting is illegal in India. Is there enforceability? No. Is it a contract? No. X offered to sell onions to Y, or let's say apples, okay? X offered to sell apples to Y and Y agreed to buy it at 100 rupees per kilo. Was there offer? Yes. Was it accepted by Y? Yes. What does it become? It becomes an agreement. Now, Y gave money. He gave money in advance. But X is not giving apples. Can Y file a case? Yes. Is it a contract? Yes. All elements are present. It's a contract. X invited Y for dinner and Y confirmed, I will come sharp 8 o'clock. So X made all the arrangements. He arranged for high quality of food. He created an ambience, etc. But Y did not turn up. Now, was there offer? Yes. Was it accepted? Yes. If Y did not turn up, can X go to the court and say, Judge, he wasted all the food. Arrest him. Is it enforceable? No, he's just our friend. We will not file a case against our friend. We never even thought of it. Is it a contract? No. There's no enforceability. It's not a contract. It's just an agreement. He's our friend. We don't file cases against friends. Students, from this, can I conclude that in case of social, that is between friends, there's no enforceability. I never even think of filing a case. But in case of business or commercial transactions, I didn't even tell you. You thought and gave the answer on your own that, ma'am, if Y has paid money but X is not delivering the apples, Y can take action. You told me the answer on your own. So, in case of business or commercial transactions, law presumes that there is enforceability. Parties intend to create legal relation. There is enforceability. It is assumed. But in case of social agreements between friends, later we will discuss domestic agreements. Domestic means agreement between husband and wife. There is no presumption to create legal relation. I would like to elaborate on this. Okay, I would like to elaborate on this. Let me add one slide. Okay. You can write along with me in your notebook. In case of business or commercial transaction, we presume, okay, we presume that there is enforceability. Okay, we assume that, yeah, parties will file a case. If one party defaults, other party will take action. It is presumption. You need not even agree separately. See, I didn't tell you, but you told me on your own that, ma'am, if Y has paid money and X is not giving apples, Y can file a case. In my first example, when X had offered to sell his flat to Y, X gave the flat, but Y did not pay 50 lakh rupees. I did not mention, but you on your own told me, ma'am, if X has given the flat and Y is not paying money, X can file a case. So, in case of business or commercial transactions, we assume that yes, there is enforceability, there is intention to file a case. However, in case of social, between friends, domestic, between family members, husband, wife, father, son, mother, daughter, between family members. So, in case of social or domestic transactions, we assume, okay, we presume that there is no enforceability. We assume that parties never intended to file a case. Now, let me give you one more example. Okay, we discussed an example of friend inviting the other friend for dinner. Now, let me give you one more example. You told your mom, Mama, if today I get full marks in my test, will you make pav bhaji for me? Mom agreed. You got full marks in your test. You reached home. You told Mama, I got full marks in my test. Today we will have pav bhaji for dinner. She said, okay. You went to play. You came home. Mama served dinner and you saw that she made a very boring vegetable. Something that you don't like at all. She said, no, no, today no, I was very tired. I didn't make pav bhaji. I will make it tomorrow for dinner. Can you tell your mama, Mama, come to the police station. I want to file a case against you. You did not fulfill your promise. When you had entered into a contract or an agreement with your mom, you never had any intention to file a case. You must have not even thought about it. You must have never even thought that if your mother doesn't make pav bhaji, you will file a case against her. So law presumes that in case of social or domestic agreement, social means between friends. Domestic means between family members. We assume that parties never had intention to sue or never had intention to file a case. We assume it. This is between family members. We presume that there's no enforceability. Now, let's say that husband promised to give 25,000 rupees to wife. Okay. Wife said, wait. This is a domestic agreement. If you promise and later you don't pay me, I will not be able to file a case. Wait here only, wait, don't go anywhere. She went to the room, brought a piece of paper and a pen, and she told the husband, you write and give it to me. If you don't pay, I will file a case against you. Now, in this case, she is adding enforceability. If the husband fails to pay, can the wife take action against the husband? Yes. So even though the agreement is between husband and wife, it's a domestic agreement, you can separately add enforceability. Ma'am, is it always to be in writing? No, it is preferred because writing shows proof. Even if it is an oral agreement and you have a witness, you can tell the witness, see, you tell me, didn't my husband promise in front of you that he will pay 25,000 rupees to me? And didn't I tell him that if you don't pay, I will file a case? Tell me, witness. Yes, yes, ma'am. Yes, yes, my lord. The wife had told the husband that if you don't pay, I will file a case against you. Some intention was shown, then even though it is a domestic agreement, it will still be considered as a validly enforceable contract. So, law presumes that in case of social or domestic, there is no intention to sue, no intention to create legal relation. However, you may add it separately by showing your intention either through words or in writing, either orally or in writing. If you add enforceability, then it will definitely be a valid contract. So, students, this is something which I wanted you to be aware of. In my next session, I will start the essential elements of a contract. But before that, I would like to read all this from the notes. Law is nothing but a set of rules. These are my notes. So you please highlight all this in your textbook. Yes, please highlight all this in your textbook. So law is nothing but a set of rules. The law of contract was introduced to define the rights and duties in a business transaction. This act came into force on 1st September 1872. Earlier, yes, what about the contracts which were entered before 1st September 1872? To those business transactions, okay, to those business transactions, your personal law, English law, or maybe the law of the king or the governor, they were applicable. So there was no unified law. But after 1st September 1872, this act will apply to the whole of India. It will apply to all the contracts entered in India. The act applies to the whole of India. It also applies to Jammu and Kashmir. We discussed that in detail. What is a contract? A proposal, when accepted, first becomes a promise. Every promise, even if there is a single promise, it will be an agreement. And every set of promises forming consideration for each other is an agreement. And what is the simple equation? Agreement is nothing but offer plus acceptance. So agreement is nothing but offer by one party, acceptance by the other party. What is a contract? An agreement enforceable by law is a contract. Okay, so these are the two elements. We need an agreement. We also need enforceability. What is an agreement? Agreement is nothing but offer plus acceptance. So can I say contract is nothing but offer plus acceptance plus enforceability? What is the meaning of enforceability? Enforceability means intention to sue, intention to file a case. If one party defaults, other party can take action. You can write that also. Ma'am, we just wrote that in our notebook. We will write it multiple times so that we are able to learn it. Okay. So if one party defaults, other party can take action. This is nothing but enforceability. In what kind of transactions we presume that parties have intention to sue? There is a presumption that parties intend to create legal relation, business commercial or social and domestic. Business commercial. In case of business or commercial agreements, the usual presumption is that parties intend to create legal relation. But in case of social or domestic agreements, the usual presumption is parties do not intend to create legal relation. Why is it so? Please have some patience. I will discuss it with you when we study the case law Balfour versus Balfour. So there are still so many things that you need to learn. Ma'am, why is it so? Why is it that in case of social or domestic there is no such intention? I will give you the logic, but after some time. Okay, in these two examples, can you identify which of them will be a contract? In which of these there is enforceability? The first one will be a contract. There is enforceability because it is a business or a commercial transaction. So we assume that if one party defaults, other party can take action. But in the second example, this is just a social agreement. And we know that in case of social agreements, parties do not intend to create legal relation. We assume, okay, unless, yes, unless of course you add such enforceability, which I explained earlier. There's a social agreement. Parties have not expressly agreed. So in this case, we will presume that they do not intend to create any legal relation. There is no enforceability. In case of social agreement, at the time of formation of the contract, parties did not intend to create legal relation, hence they cannot file a case. It's not a contract. What is the difference between agreement and contract? Can be asked as an exam question. What is the meaning of agreement? Every promise and every set of promises forming consideration for each other is an agreement. So we start with the definition. Agreement is nothing but offer plus acceptance. What is a contract? An agreement enforceable by law is a contract. Wait now. Did you notice something over here? Section 2, clause B, 2, clause E. I will explain all this in my next session. In my next video, I will discuss in detail what is a section, what is a clause, what comes after section, is it subsection or is it directly clause. I will be discussing all that. Just give me some time. So let's keep this pending and we will discuss it in the next session. All right. So section 2 clause H defines contract. Contract is nothing but an agreement enforceable. I'll write it over here. Section 2 clause H. An agreement enforceable by law is a contract. Contract is nothing but agreement plus enforceability. Agreement is a very wide term. It includes both legal as well as social agreement. Yes, social, domestic agreements, everything is included over here. However, contract is very narrow in its sense. It includes only those agreements which are legally enforceable. It only includes those agreements where there is enforceability. So I am looking for enforceability. Agreement may or may not create a legal obligation. Sometimes it is just a social agreement. Contract normally creates legal obligation. All agreements, they are not contracts, but all contracts are agreements. Do you agree with this? Yes, ma'am, it is very clear. What distinguishes them? They are saying that all agreements are not contracts, but all contracts are agreement. What is the equation of contract? Contract is agreement plus enforceability. So it means to make a valid contract, I need an agreement. So all contracts are agreements, but all agreements are not contract. Agreement is offer plus acceptance. Be ready with the answer, and we will discuss that in my next session when I discuss what is a section, subsection with you. Why not discuss it now itself? I want you to try and attempt those questions on your own. I will not give spoon feeding. Huh? I will not give you everything ready made. I will force you to think. I will force you to jot down points. And only then I will discuss with you. I want to train you since the beginning. I want you to start applying your mind. I want you to start applying these concepts. I don't want to give you the answers directly. So that is going to be my approach. All right. Now, agreement is offer plus acceptance, and contract is agreement plus enforceability. So, what actually distinguishes agreement from contract? It is enforceability. If there is intention to sue, it is a contract. Otherwise, it's just an agreement. So, agreement is offer plus acceptance. It misses one very important element of enforceability. So, all agreements are not contracts, but all contracts are agreements. So, students, there are a few questions which I want you to attempt on your own. Don't look at the model answer. Just try attempting them on your own. And when we meet next, I will discuss these questions with you. And we will also study what is a section, what is a subsection, what is a clause, how to differentiate between them. I will teach you everything very practically. But in today's session, I hope that you understood all the concepts because we covered everything in detail. Learn law like never before with me, CA Preeti Agarwal. This was just the beginning. Our concepts will get stronger and stronger with every lecture. In case you have any doubt, even after going through all this, you still feel that, ma'am, there is one thing which is bothering me. Feel free to ask me, students. You already have my mobile number. I would love to solve your doubts. Don't keep it in your mind. Feel free to contact me on WhatsApp. And if you have many doubts, you can also call me. I would be very happy to help you. Okay, so go through the text once again. Try to learn it as it is. The notes are in very simple language. It is possible for you to learn each and every line. I always tell my son, the easiest way to remember is to copy everything first and then you try to learn, because once you write everything, there is a direct connection between your hand and your brain. So once you write everything, automatically most of it gets registered in your brain. Then you don't have to put more effort in memorizing. Will you do it for me? Will you try it? So first you copy everything as it is. Don't copy the examples, just leave it. But for theory, copy all the theory points as it is and then close the book and try to recall whatever you can. Try to learn. See, then when you learn it, it will be very easy because you have written everything once in your own handwriting. All right, so students, with this I take your leave, and in my next session I will be discussing the question answers with you, and we will also go through the meaning of section, subsection, clause, etc.